Hello and welcome to the Political Orphanage, a home for plucky misfits and problem solvers. I'm your host, Andrew Heaton. And unless you've been living in the woods, you are no doubt aware that former President Donald Trump has been convicted of multiple felony counts in a New York court as of last week. I, however, was living in the woods, so I found out later than you. I have been traveling/camping on my way back from Washington, D.C. to Texas, and was deep in the mountains of West Virginia in Scrumpox County or Bulbous, West Virginia. I don't know. It was beautiful. I don't know why I'm putting West Virginia down. It was absolutely gorgeous, but I didn't have cell reception, and I went on a 2-hour hike. At one point, enough electromagnetic energy was able to dribble out of the sky, or however cell phone signals work, that my mom squeezed one into my phone and said, Donald Trump's been indicted on 34 counts. That's how I found out. I found out in the middle of the woods and then could do nothing because the phone reception was no longer there, hiked back, eventually got back into cell phone range and pieced together today's episode with two fantastic guests, and as well as a fair amount of research that I had to do while in the woods. If you hear sounds of crickets, owls, bears, axe murderers in the background, that's because I'm in the woods as I recorded this and put it together and put it out early to try and be relevant to this very big story. Now, in preparation for researching said story, I went through a lot of media coverage because what I was trying to figure out was the following. What the hell happened? What happened exactly? And that's not a dumb question because I'm not an attorney and I wasn't in the jury and I've never been convicted of a felony as a former president. And I wanted to figure out, okay, what did he actually get convicted on, and would I agree with said conviction? That seems like a reasonable starting point. And I have never in my entire career seen more deviance in the coverage of this event in partisan media. If you are watching blue team media, this trial was rock solid, an elegant trial even, a truly elegant trial. And the level of borderline color commentary following a Super Bowl is truly outstanding to watch. I'm catching up on all of this, and I'm watching pundits go, you know, the prosecution did a great job, but we need to talk about the defense. You know, the defense had a hard play. They made a smart play. They didn't get it at the end of the day, but they deserve some respect for what they attempted to do. But I think what we really should do is comment on the prowess of the jurist and the jury. I mean, it sounds like color commentary for a football game, and it's fawning. The judge is the most judgely judge who has ever sat the bench. He is Black Stone, reborn. I did not believe in reincarnation, but now that I have seen this judge, I know that Hammurabi has returned to us. And can we talk about the jury, how attentive and really talking about what a great trial it was in every capacity. And then you flip over and you watch red team media, and we are now living in a banana republic. We're not even a banana republic, a banana dictatorship. There is absolutely no difference between what Putin did to Navalny and what Biden is doing to Donald Trump. And it is a kangaroo court, and mark the date, the republic fell that date. That is when the judiciary decredited itself and delegitimized itself, and so on and so forth, of this incredible sense of the institution has collapsed. This was rigged from the very beginning. I want to figure out what is the truth in between these things. The easy thing for me to do, the simple thing to do, and I have to acknowledge here, the incredible labor-saving thing to do would be just to split the difference and go, a pox on both your houses, partisans. Partisan's going to be partisan. It's somewhere in the middle. But that's frankly kind of lazy, isn't it? Anybody can do that. What I want to do today, what I'm going to do with you, is try to figure out what exactly happened to the point where by the end of the program, I hope you and I can both cogently discuss this. And if you are suddenly in an elevator and somebody says, "What did you think of the Trump trial?" that you will be able to have a good opinion on the mechanics of the law itself that he was prosecuted on, the position of the attorney that prosecuted him, and the validity of the courtroom in which it took place. Those are the three things that I want to cover in today's program. Here's why this is important. In my mind, it has less to do with how the election's going to go. I don't, frankly, think this is going to affect the election that much anyway. I think that if there were people that somehow had not made up their mind about Donald Trump and Joe Biden, they just hadn't paid attention, somehow blissfully avoided that the last few years, I think that they're a small enough group that this isn't going to affect them. For the people that were kind of on the fence about Donald Trump, I'm thinking that January 6th, or more likely the build-up to January 6th of refusing to accept the outcome of the election, that would be a bigger thing for most people, I think, than the felony charges. So I don't, perhaps I will eat my words on this. I don't think this court trial will significantly change anything. I think that all of the court trials cumulatively have benefited the Trump campaign, and that it's given him more press coverage, and it has allowed him to run a campaign as the underdog who's being targeted by the administration and so forth. But I don't think that it's going to be a game changer. In that regard, the reason that I'm concerned about all of this and I'm fascinated by all of this is the long-term effect on our country. If the most strident pundits on Blue Team are correct about their analysis of the court trial that just wrapped up in New York, then there was a legitimate outcome done by a judge, jury, and prosecutor, and it is a victory of the court system and norms and rule of law, and America had its choice on whether or not to hold every citizen accountable to the law equally, even that of a former president. And if President Trump and all of his surrogates are calling it into question, that is them trying to delegitimize the court process because they don't like the outcome, just as they tried to do in 2020. He didn't win the election, and he tried to delegitimize the election and caused long-lasting damage to our democratic process. That is now happening to us within the judiciary. Those are very big prospects to consider. But on the flip side, if the strident Republican commentators are correct, and this is a kangaroo court, a corrupt court with a corrupt judge and a corrupt prosecutor and jury members who were in the bag from the beginning, and we are indeed seeing a heinous misapplication of justice, then we've got a whole other set of problems that we need to consider. And those are that we're living through something akin, I suppose, to when Woodrow Wilson tossed Eugene V. Debs in the clink. Now, if you're unfamiliar with this, quick side note, real quick. Last weekend, I was in Washington, D.C., and I was covering the Libertarian Convention at which Trump spoke. And one of the earliest comments he said was that Joe Biden was the worst president in American history. And I immediately thought, well, Woodrow Wilson got us into World War I through a campaign, got us into World War I, threw one of his opponents into jail for sedition, and then played a KKK film in the White House. I have to say, I think Woodrow Wilson was much worse. Wilson, when he was running, threw Eugene V. Debs, the socialist candidate for the presidency, in prison, where Eugene V. Debs ran a campaign from prison. He did so because Eugene V. Debs rightly opposed the draft for World War I, and so he was locked up on charges of sedition. It was lawful, but it wasn't right. It was a lawful process that was done by the courts. The Supreme Court, I believe, got involved. They even agreed with the decision, but the law was bad, and the application of the law was also bad, and we might be living through something like that. Both of these are very serious charges, and I want to try to get down to the root law of all of this in today's episode. So without further ado, let's jump in. My guests today are Paul Townsend and Anna Gorisch, both beloved attorneys of this particular program. Paul Townsend is a former prosecutor and current defense attorney in New York. He is my defense attorney when I commit crimes in New York. I rely on him regularly for getting me out of the clink. Hello, Paul.
Hi, nice to be back. Thanks so much.
Anna Gorisch is an immigration attorney and my personal fixer. Whenever I have to pay hush money to porn stars, I reach out to Anna and I say, Anna, can I just put this under your retainer? We'll work something out of the back end. Hi, Anna.
Hi, Heaton.
Delighted to have you both on again. What do you guys want to talk about? What's been in the news?
Well, I would love to talk about your decision to use Anna as a fixer where you'll figure stuff out on the back end, because apparently what we've just found out in New York is that's a great one-way ticket to any felony conviction.
Let's talk about the Trump trial. So I've been going through a lot of content, a lot of podcasts, and a lot of articles, trying to keep myself abreast of the Trump trial. Let's do this from the beginning here. Anna, can you succinctly explain what Trump was charged and convicted on?
No, nobody can. I mean, that's the truth, though. And I think that, we should lean heavily on Paul here because he is a defense attorney and has been a prosecutor. But the thing that's nobody knows, because the jury didn't have to agree on the theory of the crime. So, and we don't know what each of them independently decided. So all we're really sure of is he was found guilty of classifying hush money payments as legal expenses. And beyond that, I'm not really sure. Paul, maybe you can help us out here, because I think it's either tax fraud or additional document fraud or federal election interference.
Those are the three possibilities of what could have been an underlying theory of the Trump conviction. So let's start from the beginning. So if you have been following this case, as many people in this country have been glued to their TVs, their laptops, their phones, however they get their media, and they are watching and consuming media coverage from the left, from the right. And what they know is that President Trump is on trial for something called falsifying business records. And what you're never going to hear or read is what exactly he is alleged to have done, mostly because no talking heads, no pundits, and very few attorneys that practice in the criminal space that I speak to are able to actually articulate what it is that he did. Even people who are watching this trial and watching the coverage daily, they're getting a lot of Michael Cohen, of David Pecker, of all of these different people who are testifying about what happened back in 2015, 2016, 2017. And yet at the end of the day, not many people who I've spoken to have been able to walk away and say, okay, so Trump is accused of doing A, B, and C, and either I'm convinced or not. Most of them are just saying, well, he's obviously guilty because didn't you hear the testimony of Michael Cohen? Therefore he's guilty. Or you heard the testimony of Michael Cohen. You can't trust him. Obviously, he's not guilty. So let's start with the basics. Here's what Donald Trump is accused of doing at base. He, through his attorney at the time, Michael Cohen, who was his personal lawyer, back in late 2016, around October, paid $130,000 to Stephanie Clifford, who goes by the porn star named Stormy Daniels, to basically keep her quiet about a 2006 sexual encounter that Trump had with Daniels. Now, Cohen paid this money out. The election happens in November of 2016. Trump is inaugurated. He takes the Oval Office in January of 2017. From there are a number of payments the first couple months from the Trump Organization Trust, which is what Trump has put all of his business assets into while he's president, because he is supposed to have a barrier between his business dealings while he's president. But Michael Cohen is his personal attorney, so starting in about April of 2017, he's paying Cohen from his personal account, and he is labeling these payments, both from the Trump Organization and from his own account, as legal expenses. And there's no argument that during this time, Michael Cohen is Donald Trump's personal attorney. So he's getting paid $35,000 a month in what are just deemed legal expenses. He's on retainer for the Trump campaign. So the crime that we are talking about here is that these $35,000 payments to Michael Cohen are alleged to be the result of a conspiratorial agreement to repay Cohen for the money paid to Stormy Daniels, which was mislabeled on the ledgers for the Trump Organization and Donald Trump's personal finances because it was not for legal services, as it purports to be, but it was actually hush money paid to Stormy Daniels so that she would not come out, tell her story in October of 2016, and effectively ruin Trump's chances for being president. And that would be a misdemeanor. That misdemeanor had the statute of limitations run because the misdemeanor statute of limitations in New York is 2 years. So what Alvin Bragg did, the district attorney of Manhattan, is to say, okay, so the misdemeanor is run, but we can still potentially go forward on a felony charge because there is a felony falsifying business records charge. But what that requires is that the underlying falsified business records were either done to conceal or commit a different crime. So they determined that, well, it might have been this falsifying business records, this mislabeling of legal expenses is either some sort of campaign finance violation or a tax fraud or a New York State Business Association general business law violation. So if it's any of those things, well, now we've got the second crime, so we can bump this up to a felony, and now we can prosecute him. So that is at base what Donald Trump is accused of actually doing in New York.
Thank you, Paul. That was very succinct and very helpful. I want to make sure that I understand this because, as you both have pointed out, it's rather complicated. What he's been convicted of is the cover-up of the crime. The cover-up is relabeling hush money, or what we would normally call a non-disclosure agreement, relabeling that as a legal fee in order to, I guess, not draw attention to it or sweep it under the rug or something. And that because that is covering up the underlying crime, the cover-up itself under New York law is a felony. However, what the underlying crime is has not actually been designated in the trial itself, nor has he been convicted of it. The jurors have all been independently arrived at the conclusion that he committed a crime, but they've not specified what that crime is, and that the NDA hush money misfiling was a deliberate cover-up and therefore is a felony rather than a misdemeanor and is germane to the timeline that would have otherwise knocked it out in terms of statute of limitations. Give me a percent on how accurate I am getting this.
One thing, so there's a little bit of a flip. So they agree on the underlying crime, the business fraud, the mislabeling of the funds. It's the concealed crime that they are not required. And I have major problems with this from a legal standpoint. They are not required to all agree what crime was being concealed by mislabeling the funds. So the government offered 3 different plausible other crimes that they are arguing. If you find any of these, then you can convict. And the way that New York law shakes out, the jurors are not required to unanimously decide on a crime. They can split evenly. They can go 11-1-0, 4-4-4, as long as they find that any other crime was committed as concealed by this crime, then they can convict of the underlying felony.
So this is really helpful. It's something that I want to get to immediately, which is the problem that we have with this, which I agree strikes me as fishy. I would not have brought this to trial if I were, hold on a second, I'm in the woods and I have a second dog. There's 2 dogs in the camper now. Who are you? Goodbye.
Wow.
Hey, Wallace, what do you think? Uh-oh.
Ooh.
Okay. Goodbye. Sorry, it was just very funny. I have Wallace is directly behind me, and then this other dog just came in and hopped into my lap, and I was like, "Oh, great! Look at me!"
You just the dog whisperer.
Yeah,
you're going to give Caesar Milan a run for his money.
Yeah. Okay, so back to the trial at hand. Okay, I would not have brought this to trial. I think that, and by the way, Merrick Garland also decided not to bring this to trial. Federal prosecutors looked at the same data and said we don't have a case. They didn't go with it. I thought this was a real stretch and a real contortion from the beginning, and it very likely went into the category of selective prosecutor, where somebody is actively trying to get a particular person rather than apply the law. I'm with you on all of these points. When it comes to this kind of quirky situation, Paul, of under New York law, you don't have to designate what the underlying crime is or the object of the crime. You just have to designate the cover-up for it. Is the problem that we have here with the trial itself or with the law as written by New York? Because one of the things that keeps being brought up by Trump and by conservatives is that this is rigged, the judge is corrupt, the trial was absolutely unfair and illegitimate from the beginning. What I'm trying to figure out is it that the New York law is screwed up and it is being applied correctly, so a bad law is being applied correctly, or is it that the law is being misapplied by a overzealous vengeful prosecutor and a politically suspect judge?
I have had a similar situation in multiple cases. I've written several motions decrying the fact that a non-unanimous verdict is acceptable to convict under these circumstances, and it is the rule of law in New York. But my arguments, which I stand by, and I still think I'm right about this, is that I don't see how myself or Todd Blanche, who's Trump's defense attorney, is expected to craft a defense when the theory of what the defendant actually did isn't set in stone. It's how do you create a strong defense when the prosecution's not telling you exactly what your guy is accused of doing wrong? They're saying, well, it might be this, it might be that, it might be that. So now you've got to come up with different defenses for each of the potentialities that are being given to the jury. And so you've got to now focus on a bunch of different things, some of which are even mutually exclusive, which means that your defense has to thread a very difficult needle of saying, okay, so if you're in the camp of saying, well, it was a federal election law violation, then you're going to have to do one defense. If you think it was a New York Business Association law, then here's a different defense. If you think this was a violation of the tax code, here is a third defense. And it's extremely problematic for a defense attorney to not know throughout the entire trial, as the evidence is coming in, how do you cross-examine when you don't know what the government's theory of the case is? It's wildly inappropriate, and I think it's a due process violation for a defendant not to know specifically what he's being accused of. But unfortunately, that is the law in New York, and so it's not Juan Merchan and his court, doing a selective, bastardization of New York law in this case. That is the law in New York. That is permissible. I just have massive problems with how it is applied generally and how it was applied in this case.
Got it. Okay, that's really helpful, Paul. So this is a situation where New York has a weird funhouse mirror law on the books, and that is what Judge Merchan and is working with, and what Alvin Bragg decided to try to contort in order to get Trump. But from your perspective, it is the law itself as written is a significant part of the problem. It's not that there was an active judge or a unfair jury selection.
Well, yeah, I don't see that this was a misapplication of the law. It was certainly a novel theory of how to apply it. But that is the law. What they did and the way that they argued for the conviction was not outside of the bounds of what is acceptable in New York. It certainly was acceptable, and you can argue back and forth on whether the evidence was there, whether it wasn't there. These 12 people apparently thought it was, but the argument that I have would have been, suited for a pretrial motion of this is impermissible because they are not telling us which theory they want to do, and you're allowing for what I would consider an inconsistent verdict by giving the jury the opportunity to not unanimously agree, but still convict.
I agree with everything as Paul is saying. And I think that, obviously I'm not a criminal trial attorney, so my view of it is different, although I do have, legal training. But the immediate question for me is, how is this law not a violation of the Sixth Amendment, which includes the right to be fully advised of charges against you? And, as Paul said, if it's a multiple choice verdict then that just seems, first of all, it's counterintuitive. I think that any American should bristle just a bit at the idea that they might have to defend themselves against unnamed charges, or deal with a jury that gets to pick from a menu of what they think you might have done. But Paul, maybe you can clarify. I think one of the other things about this that makes me uneasy is that not only can you have kind of this multiple choice option when it comes to the theory of the crime, but that Trump has neither been charged with any of those other crimes nor convicted of any of those other crimes. And in this case, they were not required to prove the other crimes beyond a reasonable doubt. Am I right about that, Paul?
Yeah, absolutely. And it even goes a step further, as you mentioned earlier, Andrew. So one of the theories that was put forward by Josh Steinglass, the lead prosecutor in the case, was that Trump committed federal election campaign finance violations. But as you said, Merrick Garland looked at that. The Department of Justice looked specifically at this claim and said, yeah, we don't think there's enough. We're not going to go forward. And believe me, I think if there was enough to go forward on this isn't a situation where the Department of Justice would have just stepped back and said, you know what, it's just not worth it. It's a petty crime. We don't really care that much. It's not worth the resources. I think we can pretty safely say that if they thought they could make it out, they would have gone for it. But they didn't. Yeah.
And I think that one thing that supports that contention is that Hillary Clinton actually did get into trouble for the 2016 election. And she was fined some 100,000 or something by the FEC because she classified the Steele dossier stuff as legal expenses. So they're not afraid to go after people for this, is I guess the point, right?
One would think that Garland would feel more comfortable. I mean, theoretically, if there's any level of personal interest whatsoever, one would think that he would feel more comfortable going off after Trump than he would, say, Hillary Clinton or somebody like that. So I'm not surprised by that. I do think that you're right that the underlying crime is very squirrely. Merrick Garland and the Justice Department declined to pursue Trump on having violated campaign finance law. So already, if you're Alvin Bragg, you're making the case that one of the three quantum state crimes that has allegedly been committed was a violation of federal election law, which the feds themselves have declined to prosecute on. But if you also are making that case, you're also making the case that you are in a state court prosecuting Trump on a federal crime, which I think is a jurisdictional problem because a federal court would have preeminence over a state court. There might be law in the books, and Paul, you can answer this, there might be law in the books that there are duplicative laws where if you violate a federal crime, you can be charged in the state on it, but if the feds ever tapped it, they would get preeminence on it because it is a federal crime. So that whole thing has struck me pretty squirrely from the beginning.
It is squirrely, and here's the rejoinder to that, because this was something that was discussed and kind of litigated a bit pre-trial because this topic came up. And one of the reasons that so many people had an issue with the rulings that Merchan had, and one of the reasons he took a lot of flack from people on the right, was his ruling on this particular issue. And without doing probably 20 hours of legal research, I don't know if he's actually right or wrong on this, but the way that they got around it is they said, okay, so we have this crime, falsifying business records. We think we can make that out. We have enough to go forward on it because, they selected legal expenses on QuickBooks instead of hush money to porn star, whatever that is. What bumps it up to the felony is the attempt to conceal or commit another crime, and then it has a phrase in there, by unlawful means. And so the way that Bragg's DA's office interpreted that is unlawful doesn't only apply to a violation of New York state law. Unlawful could apply to federal law because a violation of federal law is an unlawful act. Therefore, it doesn't require the underlying or concealed crime to be a separate violation of New York law if the jury finds that he did anything unlawfully or using unlawful means to accomplish the concealing of the crime, then it can be the predicate, or not the predicate, the subsequent act that's being concealed. And therefore, a violation of federal law can, for the purposes of making this misdemeanor a felony, be used by the state prosecutors.
What I'm trying to figure out this episode is, A, what the hell happened, and B, is the trial that just wrapped up a example of law and order and norms and the legal system being executed properly and we are a nation of laws, or is it B, a kangaroo court? So it sounds like thus far, Paul, what I'm hearing from you is the main contortions here are the law on the books. That the big problem we have is that New York has crafted itself a poor set of laws that has been applied in this court that is overly broad and deprives clients of due process. But that so far the problem is not the judge, the prosecutor, or the jury. The problem is the law on the books. I want to explore some of the kangaroo court allegations that have been brought up by conservatives in order to get to the bottom of this. So Trump has been very vocal about this from the beginning. This is not a situation where he is saying, I feel that the prosecutor is going too hard on me, or I feel that the prosecutor is being overzealous in application of the law. He said this is a corrupt judge, his words, and that this is a rigged court. Now, I've tried to do my due diligence on what are the base allegations that he's making. What is the root of what he's talking about? With the judge, there's something about his family making money off of it, which I'm unaware of. Perhaps you all know that. I do know that the judge made a $35 contribution. He made a $35 campaign donation to a pro-Biden, anti-Trump political organization, and earmarked in it stopping the radical Republican agenda or something to that effect. So I'll kick this to you both. If a judge makes a $35 contribution to a political opponent of the person on the trial, should they recuse themselves? Is that sufficient for them to say, I have been politically compromised, I clearly have a position on this? Is there a monetary threshold? Is it something where the judge has to have 100% propriety in terms of any political opinion? What do you make of that?
I don't know that there is a bright line, and I expect it varies by state. Now, I think I read somewhere, and I'll let Paul confirm this, that in New York, judges are actually not supposed to donate to campaigns at all. But, you know, it was a small donation. It was only $35. And his daughter is a Democratic fundraiser, I believe. And so she's been able to use this trial as leverage for fundraising. Those are kind of the accusations related to that. But I think that it would, you know, if you flip it and ask the reverse question, I think then it kind of becomes clear. Imagine a world where a judge had given $35 to MAGA, you know, and the Democrats. I can't imagine that there wouldn't have been an uproar about the judge overseeing the trial when he'd given $35 to, you know, stop the steal or something like that. So I'm not sure if there's a statutory threshold or what the rules are for judges donating money, but I think it's a bad look at the very least.
There are two different questions at play here. And depending on your desired outcome, you're asking one or the other question. The first question is this a conflict to the extent that it would require his recusal? And the answer is no. There is no New York rule that says if you make a political contribution that you are then barred from sitting as a judge in a case that touches an area of political inquiry. Juan Merchan was not required by any rule of law or ethics to recuse himself based on a $35 donation. There is no statutory threshold for donations made. The second question, though, which is what you're going to hear conservatives say, is, well, isn't the appearance of bias sufficient to require somebody to recuse themselves? And that is a very nuanced question because there is no bright line answer. It's just, what do you think the appearance of impropriety or the appearance of bias looks like? If the judge says, I made a $35 donation, it doesn't matter. I can be fair. I can be impartial. I can be unbiased. Then how do you can't prove otherwise. And it's up to the judge to determine whether or not he is compromised, and he has to, take a fair inventory of his own feelings on a topic like this and come to that conclusion. In this particular case, there's a $35 donation, which we all agree is not a whole lot of money. However, I know a number of judges in New York, and to a man, they all, or woman, they all assiduously avoid any political donations. They do not do it. Not because they are not allowed to by law, they all are, but none of them want the accusations of bias that will come from any kind of donation. They think it is improper for them to give money to political campaigns. Some of them will occasionally speak somewhere. They will take no money for it, but they will not. They will not donate money to campaigns, and most of them will avoid any involvement in kind of political electioneering, campaigning, anything like that, because they view the judiciary as separate from any kind of electoral politics, and they think that it should be set apart and it should not interact. So I understand why people are a little bit miffed that the judge in this particular case, took that step to actually make any kind of donation. And, I think the daughter thing is way overblown. I don't personally think it has any bearing on this case whatsoever, whether or not his daughter is an operative for the Democratic Party and whether she is a fundraiser. That means absolutely nothing to me. That's like saying, Clarence Thomas should recuse himself because of Ginny. Like, it just doesn't make sense.
Recusals happen on a regular basis with judges, but as I understand it, usually the recusals are because I, the judge, was formerly a prosecutor and I was involved on the case that is now before me. I cannot, for obvious reasons, rule on a case that I myself was a litigant on, or I previously defended this person. When it comes to things like monetary issues and recusal, it has to be fairly direct, and there's pretty good precedent on this, where if I am a state Supreme Court justice or a United States Supreme Court justice, and we have a decision to make on student loans, as recently came before the Supreme Court, the fact that I have a nephew that has student loans is not sufficient for me to recuse myself. Yes, there's some financial element within my family, but it's so broad. It would really be more like, I have stock in the company that's before me. So I like that. That is a situation where I would go through it. Or put it another way, my dad's a judge. I work in political media. So, but what I do is not related to my father's rulings. So if theoretically I take up some particular judicial issue like today, and something like that comes before my father's court, it doesn't have any effect on his bearing, or should not have any effect on his bearing. So I'm with you, Paul. Based on what we're saying here, if it's not a situation where like the judge is employing his daughter as a bailiff or something, not just for this case, or some weird financial thing where the court is diverting funds, that sounds like a misnomer.
I think that this is more of a, kind of 30,000 foot issue. But one of the reasons this is so politically contentious, I think, is that you're juxtaposing Juan Merchan, who has given money to Biden's campaign, against a campaign that's kind of ongoing to get Samuel Alito to recuse himself from a bunch of cases because he flew a flag. So I think it just makes it more, I think that is one of the reasons and one of the talking points that, the MAGA side is gonna roll out inevitably, is that, on the one hand, we're looking at Merchan, who's given money to a political candidate and saying that's okay. And I agree with Paul generally. I think recusal should rarely be enforced or required. I think that most of the time judges can set aside their personal feelings about politics and deal with a case. And I think that's true at the Supreme Court level as well. But I think that that's one of the reasons that this is also politically awkward, is, because you have Trump being prosecuted by somebody who's given money to his opponent. And at the same time, people are calling on Alito to recuse himself from every case involving Trump because his wife flew a flag upside down or something for, a couple days.
We are able to trust that judges are able to separate things like that out, that they have their own personal opinions, but they don't let that bleed into their job. That's why of all of the people, there's 8 million people in New York and there's, 35 judges in New York County. That's why these are the people that we trust to do this type of thing, because we know that these are presumably, ideally, not always, but we want to believe these are the type of people that can put their own personal feelings aside and say, this is what the law is. That's my job. I'm the arbiter of the law in the case, and I will uphold the law and apply the law fairly.
In terms of the political side of this, something that Trump brought up as he was leaving the court following the conviction, he said, this was rigged from the beginning. They did this case in a district of New York that voted 95% Biden, 5% me. We tried to get the trial taken to a district that was less overwhelmingly Democrat. The courts refused to do it. And the implication is this was almost like judicial gerrymandering, where they tried the court in such a way as they knew that the outcome would be favorable to Democrats. So my question is, when you're doing jury selection, can attorneys ask you how you voted? Is that allowed? And is that something that is taken into account? If you have 10 jurors that voted Democrat in a case that has a direct political implication, can juries be selected based on that? Or in the same way that we want jurists to be able to be impartial regardless of how they voted, do we have that same inclination towards juries?
Yeah, the short answer to that is no. You cannot ask a juror who they voted for. Your voting in this country is a very private and sacred right that you have. It's the reason when you go into a voting booth, it is covered. Nobody is allowed to look over your shoulder and see who you are voting for. In this particular case, the judge instructed both parties prior to jury selection process. They can ask a number of different questions, which could kind of hint at maybe finding out who the prospective juror voted for, but you cannot straight up ask, did you vote for Joe Biden? Did you vote for Donald Trump? Did you vote third party? That is an inappropriate question, and it does not have anything to do with whether or not somebody has the qualifications to be a juror. That being said, on the questionnaire that all the prospective jurors filled out to be considered for a juror in this case, there were questions like, where do you get your news? Which is a question that comes up on almost every voir dire jury selection process. And there were maybe 10 different various media outlets that were there, and prospective jurors were instructed to check a box on every one of them that applies. So if you're looking at a questionnaire and prospective juror number 631 says, I get my news from MSNBC and CNN and ABC, and that's it, you can pretty much assume that this was not somebody who voted for Trump. On the other hand, if somebody checked the box and said, I get my news from Truth Social and Newsmax and One America News Network, you could pretty much assume that this is a Trump voter. I mean, it doesn't obviously necessarily correlate one-to-one, but you can make reasonable assumptions about this type of stuff, and that's what attorneys do when they're assessing whether or not this is somebody I want to put on the jury.
Paul, if you were trying to do a mistrial or appeal, would you bring up the particular district that this was done in? Would that be relevant to you in terms of trying to get this thrown out?
No. The bar to relocating a trial is so incredibly high. It's difficult to do, and there's a good reason for that. There's a strong favor towards trying a case where the crime happened. And I don't think the threshold you have to meet in order to relocate a trial for a change of venue is the motion that we're talking about here, is that your person cannot get a fair trial where they are. That is not something that I think was ever really seriously argued by the defense in this case. They obviously wanted to move it because Manhattan is heavily Democratic. The idea that just because Manhattan is a heavily Democratic island, that Trump is denied a fair trial, you would have to put such an unbelievable amount of data forward to show that he could not get a fair trial. Now, in practice, is it likely that all 12 of these jurors that sat there listening, kept an open mind and were really were willing to be swayed by whatever argument was there? That's a different question. The question of whether or not he established the necessary requirement to move venue, or whether or not that's a viable appellate point, is a completely different consideration. I don't think there was any information put forward that would give the judge, even if the judge wanted to move the venue, I don't think anything other than, it's a very democratic, place. That's not sufficient to warrant a change of venue. You're basically saying the millions of people that live in Manhattan are all mindless automaton drones that are incapable of critical reasoning.
I think that does run afoul of the whole idea of the jury system, where I have never been able to serve on a jury. I would really like to. I would love to be a jury foreman at some point. But for my friends that have gone through the jury selection process, that try to get out of it, they will, it'll be a case involving a car accident and insurance money or something like that. And the person trying to get out of it will go, hey, I was in a car accident and I have strong thoughts on insurance. And the judge will make prolonged eye contact and go, so to be clear on this, you're saying that you are incapable of making a decision here, that you are so compromised that you do not believe your powers of logic and deduction or honesty are applicable anymore. And most of the time, jurors will be shamed and go, yeah, I can rule on this. I'm capable of compartmentalizing my own political goals for the judicial outcome. Yeah, if you were to make that argument, I think you'd kind of have to throw out the entire jury system if you were going to do that. What about selective prosecution? Because I do think that there's more grist there. Selective prosecution, the idea that I have been unfairly targeted by the prosecutor. Now, I do understand that there's a difference in terms of selective prosecution between not everybody is getting targeted and I got targeted versus I in particular have been targeted. So in the former instance, the cops don't pull over every car for speeding. They might pull over every fifth car or something like that. And so if you just go, hey, a red car just drove by us, you didn't pull that guy over, that's not fair. That doesn't qualify as selective prosecution if the prosecutor came after you instead of the other 10 people. He was going to come after somebody. You happen to get the unlucky lotto ticket of who he went after. That is different, however, than the prosecutor's going after you because you're Jewish, or the prosecutor's going after you because you're a Republican, or something like that. In the case of Trump, the prior prosecutor in New York also seems to have declined. He thought about doing this particular path forward and decided against it and went with other things that we could talk about later. Alvin Bragg picked it up, decided to go with it, and seems to have kind of run on, I am going to get Trump prosecuted. Like vote for me, I'll figure out a way to prosecute Trump. So I think that there's a much more reasonable argument to be made that selective prosecution is at work, but I don't know what the legal threshold is to make that argument. Yeah, TLDR, was this selective prosecution, and what is the threshold to determine that? Okay,
so I'll let Paul address what threshold there is, because I'm not sure there is a threshold in terms of, like, if you were to raise this on appeal, if there's any precedent that outlines how one defines selective prosecution. I do find it hard to believe that this was not an instance of starting with the man and then looking for the crime for the reasons that you mentioned, one of them being that Bragg ran on being able to prosecute Trump. And, as someone who's read 3 felonies a day, and, they could probably find something on pretty much any of us, which is, and I think this is where this trial makes me the most uncomfortable, is because they started with a misdemeanor that, honestly, I'm not even sure that he's completely guilty of the misdemeanor. And then they bootstrapped it onto other charges to make it a felony so that they could get around the statute of limitations. And so you have a former president. We've never prosecuted a former president before, and they're prosecuting a former president and someone running for office currently for what is really a misdemeanor bookkeeping crime. And that, is not the kind of crime that I would think in New York just screams, I must be addressed now. I am ruining people's lives. I think that, we were, Paul and I talked earlier, and I was mentioning that, you go to New York and the toothpaste is locked up rather than the people who steal the toothpaste. So in a city where there seems to be a general reluctance to upgrade misdemeanors to felonies, and is rather like maybe a jurisdiction where you're more likely to get the flip side of that, where a felony's downgraded to a misdemeanor or somebody gets probation for a felony. It's very hard for me to believe that this was just a case that was crying out for, that this was what is haunting New York and needed to be addressed right now. I'd love to hear Paul's comments on it because he knows more about the details, but it's very hard for me to believe that this was not selective.
Right. I agree with you, Anna. I think that it was in a broad sense a selective prosecution, but I am curious as to what the legal threshold is to throw out a case based on that. Paul?
Okay, so let's discuss first off what is selective prosecution. What does a defense have to establish in order to make the claim that the people, the prosecutor, is selectively prosecuting? So in the analogy of people driving down the street, the fifth person gets pulled over. Every fifth speeder gets pulled over. The cops say, this guy's doing 75 and a 25, 75 and a 25, 75 and a 25. This guy now doing 75 and a 25, we're going to pull him over. And his claim of, well, the red car that just blew right by me, you didn't pull over, that doesn't excuse him. He still broke the law, and he was pulled over because he broke the law, and the law as it's applied to him was being applied technically fairly. It's just other people got away with it and weren't targeted by law enforcement. What you have when you have selective prosecution is essentially the law enforcement apparatus is looking at the situation, and they're not saying, okay, we have somebody here who broke the law. We have a couple other people who did too, but we're just going to go ahead and after this guy. What you had in selective prosecution is, we don't like this person or this entity, this business organization, whatever it is, and we are just going to mercilessly hound that party until we find something that we can pin them on. And so they dig and they dig and they investigate and they subpoena and they look around, and then they say, aha, we have something. Let's rush it to court and start a prosecution on this. And, that seems to be a little bit more in line with what happened here. You referenced Alvin Bragg's campaign promise of, I will find the crime. That was a very scary thing for myself and other criminal defense attorneys in New York to hear, because you have now the person running who ultimately wins the race for district attorney who is outwardly saying, I'm going to find a reason to prosecute this person. And I don't know what it is yet, but I'm sure it's out there, and I'm sure we can find it, and I'm sure we can move forward with it. That is not how, in my mind, as a practitioner, previously as a prosecutor, now as a defense attorney, I'm not comfortable with that method of prosecution. And had I been at a DA's office that did that, I would have a real big problem with that, because you are targeting the party before the crime. And that's really where you get selective prosecution, is when it's not that, Donald Trump committed a bookkeeping error and lots of other people do it too, but we happen to just catch this one. It's we assiduously scrutinized every aspect of his life until we were able to find something. And this just came out in the form of, Michael Cohen being the gift that kept on giving. And that gave them the opportunity to say, aha, we have it. Now we have something we can go. This misdemeanor died by the statute of limitations, but we can, connect it to the machine, run a lightning bolt through it, and Frankenstein our way up to reviving the monster and giving it life. So that's what really happened here. So to the extent that an appeal is going to have a selective prosecution, yes, that will absolutely be included. That's going to be one of the first topics. And there you can bet that any appeal is going to have quotes from Biden, quotes from Merrick Garland, quotes from Alvin Bragg, about how they are just looking to find a way to convict Trump of something. It doesn't mean that Trump's not guilty, but at that point, it almost doesn't matter because what the argument isn't, selective prosecution doesn't hinge on the innocence of the defendant. It hinges on the manner and the means of the prosecution itself.
I think I am swayed by your argument, Paul, and you as well, Anna. That does strike me as fitting the bill for selective prosecution. The one of the podcasts that I occasionally dip into that I think does very good coverage of court proceedings, unlike I'm going to say 99% of all existent media, is Lawfare. Lawfare has multiple attorneys that are on it. I think that they do a good job, broadly speaking. When I listen to it, I don't feel dumber, and I don't feel like I'm just hearing sports color commentary that happens to have court as the premise. That being said, I've disagreed with some of the takes. Roger Parloff, who's one of the pundits on Lawfare, wrote an article on their blog a couple of days ago where he compared Donald Trump to Al Capone. And he said, when you look at the habitual behavior of Donald Trump over the last 30, 40 years, he's somebody that regularly cheats his business partners, is prosecuted for fraud or consumer abuse, and has shown a pattern of willful disregard for the law. So far, I agree. I don't disagree on any of that. And then he goes, he's very difficult to get pinned down on any particular thing, and so we ought to look at this the way we looked at Al Capone, where we all knew that Al Capone was a crime lord. It was widely established that he'd orchestrated the St. Valentine's Day killings, where he murdered 7 other people, but they couldn't nail him for anything except for
tax violation.
Yeah, income tax evasion, and they finally got him on that. Trump has so clearly, willfully had this pattern of unlawful behavior that what we need to do is just get him on something. And this is the thing to get him on. And I disagree with that take. That's something that scares me, because that is, in your much more succinct way of speaking, Paul, saying that somebody is guilty of a crime and then going looking for the crime. And that seems contravened to the entire due process. Even for somebody like Al Capone, I would rather have Al Capone go free than have basically a system where prosecutors can go, look, we all know that son of a bitch is guilty. We just have to come up with a funhouse mirror to get him convicted. It doesn't really matter what the conviction is. And then to your point, Anna, you referenced it very quickly, the book 3 Felonies a Day. For anybody unfamiliar with this concept, I think it's worth considering. There was a book that came out maybe 10, 15 years ago, 3 Felonies a Day, that talks about just how over-criminalized the law is right now, how many things that people do on a regular basis that would count as a felony that would surprise them. So, for example, this is now outdated, but you loan somebody your CDs or something. Like technically you're infringing on IP property. So maybe like if I loan somebody my Kindle or something like that. There's weird things where electronic media, if you're loaning it to somebody, you're committing a felony because you're violating copyright law. And you would never think of it that way, nor would a prosecutor. A prosecutor would 99% of the time go, okay, that's not really what we're talking about. The scary part is if you pissed off a prosecutor and the prosecutor went, I know you're a wife beater and I know that you're defrauding your partners at your firm, but I can't get you on that. So what I'm going to get you on is this little felony over here that I can prove that would not normally be prosecuted. That's the thing that bothers me, and I think there's a good argument that this is selective prosecution.
I think so too, and I'd like to make a quick point. The Al Capone comparison drives me insane because, for one thing, Al Capone was very clearly guilty of not filing taxes. And that wasn't like a situation where they decided Al Capone is really a danger to society and we've got to figure out a way to lock him up. I mean, they were trying to figure out a way, but the thing is they didn't have to invent something. They didn't have to cobble together, bootstrap one misdemeanor to another to make it a felony and then have some unnamed crime. You know, the Al Capone comparison doesn't quite work for me because it just is so clear that he was actually guilty of tax evasion. The income tax law was relatively new at that point. But that to me is the stark difference between the two, is that, this was a case where there was an open violation of the law that's very easy to point to and explain. We can all say, that, oh, well, they got Al Capone for evading taxes. We're going to say they got Trump for, he made some bookkeeping
Well, we all know
entries
he's a guilty bastard.
Yeah,
we'll figure it out later.
Dude. Yeah. And I think that that's, for someone like me, I'm not here. And I think that it's very hard to keep this distinction alive, but I am not here to defend Trump, the man. And I think, if you criticize this trial, there seems to be a presumption that you're somehow advocating for Trump the man and saying and that you're MAGA and you love him, and that's not true. It's just very disturbing to me. I mean, I have deep libertarian principles. I love our Constitution and our frame for government, and this kind of trial where it's a very clear, to me at least, that they started with the man and looked for the crime and that this was celebrated, it makes me very uncomfortable, especially in consideration, again, of just like the very basic and what seems to, and maybe Paul can explain why this isn't as glaring as it seems to me, but again, the Sixth Amendment requires that you be, indicted specifically. Again, Trump wasn't even indicted for the theoretical other crime. So how is this not just a blatant violation of your right to know what the charges are against you? So it's a very difficult case to defend, I think.
Yeah, I'm in the same boat, Anna. To be clear in this, I would not have brought this to trial. It sounds to me like predominantly this is a bad law that was used through selective prosecution to get Trump. Personally, I think Trump's a shitbag. Like, outside of his ideology and his politics, just as a guy, I think he's a horrible human being. Everybody that works with him says that he gets screwed over by him. Like, he's not a good person. He's not somebody that you'd want your children to emulate. Look how we completely jumped over the fact that all of this started with him banging a porn star. Like, there's lots of reasons not to like the guy, but I care very, very much about the judicious application of the law and the universality of the law. And one of the things that disturbs me about everything that's been going on with Trump, I think that there's a kind of feedback loop that we're now entering that I'm very worried by, where somebody like Alvin Bragg goes, the norms and laws are being eroded by Donald Trump. Therefore, we need to kind of circumnavigate the law in order to stop it, which I think is the opposite direction to go. You don't want to enter a situation where you're ending up undercutting the law because you think somebody else is abrogating the law.
I think that's true. And I think it's important, too, to remember, because like you're saying about Trump, I don't like the man. I don't want him to be president. I don't like Joe Biden either. But, again, I'm not here to defend Trump the man, but there has to be a difference. There must be a difference between immorality and illegality. Being a bad dude is not a crime. And if we start by saying, well, he's a shady dude and a bad guy anyway, that I think that almost makes it worse. So I think that's a line that a lot of people aren't quite catching, is that distinction between what's moral and what's legal. And a lot of people who will defend this trial, at least people I've spoken to, will start by saying, no, this was a great trial because Trump is really bad. And then they give the list of all the other grievances against Trump. And I say, but none of those are listed in this indictment, have anything to do with this trial. And so I think that if we get kind of caught up in this idea of he's a bad dude, so it's okay that this happened to him, then pretty soon who defines who's a bad dude? And pretty soon, you cut a prosecutor off in traffic and he goes through your QuickBooks, and it's unsettling.
So I've got one more question for you all on the kangaroo court element of this, or the allegations that it's a kangaroo court. One of the things that I've also heard people bring up is that the jury had 50 pages of instructions that they were given from the judge, and that the judge did not give them a copy of the instructions. Now, I'm not surprised that he wouldn't give them a copy of the instructions. I do not know criminal law. That's why I have you all. And if I were on a jury, or if I were a judge, I wouldn't want a jury trying to play lawyer internally, where they were looking at a dense set of legal jargon and trying to make their own determinations of what the law meant. I would much rather them write a yellow sticky note of, hey, judge, what did this thing mean? And have me clarify it for them. So I understand why a judge wouldn't give a copy of the jury instructions to the jury. That does not strike me as aberrant. 50 pages, though, is a lot of complex instructions to give a jury. Is that normal? Is it warranted under the circumstances with all of the weirdness here? Or is it a thing where as Trump would likely say, it was a corrupt judge who was trying to cookie cutter his way to a preferred outcome. What do you make of it? Paul, I'll kick it to you.
This is really simple. It is standard practice in New York for judges not to provide the instructions to the jury, and there's good reason for that. Juries are instructed to make their decision based only on their own recollection of what happened on the record at trial. The only thing that they are allowed to bring back, and some judges won't even allow this, is their own notes that they took. And they are specifically instructed when they do have their notes that if your notes conflict with your own personal recollection, it is your recollection and not your notes that carry. They do not allow them to take back the indictment. They do not give them transcripts of testimony to go back and pour over. They say if you have questions about the evidence that came out, if you want to read back of testimony, you can come back into the courtroom. It will be read back for you, whatever you want, and then you will go back and deliberate. It's the same with the instructions. If you have a question about the instructions, ask your question on your little yellow note. You'll come out. I will explain your answer to you and then go back. I mean, 55 pages. I know this may come as a surprise to a lot of people. Those are relatively short jury instructions.
Really?
I routinely get jury instructions that go 80, 100. I think I've had 170-something page jury instructions that do not go back. And there's a reason for that. The judge tells them, if you have questions, if you need something explained to you, you will come out, because the judge also needs to make sure that any explanation that's given is, one, uniform, that they all get it, and two, is given by him. This is not for them to go back and try and lawyer themselves into interpreting what different things mean. If they have a question about what a specific phrase means, they need to come out and hear it from the judge. It's not for them to try and parse out, okay, well, when it says this, what's it really asking for, and have them come to the wrong conclusion and then make a decision based on that. They need to get their instructions from the judge. So there is absolutely nothing about this aspect of this trial that was untoward or out of the norm. This was the right way to do it.
Can I jump in and ask a question really quick on top of that? Because I think this is an interesting point about, the jury is the trier of fact, right? One of the things that I've seen, that was critical of this trial is that Trump apparently had gotten somebody a witness who had run the FEC, who was they were trying to bring him in as an expert witness to talk about federal campaign finance law so that the jury would understand what that actually is and means when they're considering that as the other crime. And Judge Merchan said, apparently he can testify, but only about like a couple of tiny things. And so the guy, they didn't call him, the guy decided not to testify. And I can see on the one hand that, campaign finance law is particularly complex and weird and difficult to understand, I think. So having an expert makes sense to me. But at the same time, it is for the judge to instruct the jury on the law, correct? So I'm trying to figure out what your thoughts are, Paul, about making the decision not to allow him to testify, because I can kind of see both sides of this, where you don't want a witness that, comes in and explains what the law is necessarily. But it also would have been relevant testimony, I think.
I'm going to try and be very concise on this, because I had so many thoughts about this witness and the way that it was kind of handled start to finish. I think it could have been useful for them to use that witness in the way that they intended to. But as you said, Judge Merchan limited that testimony to specific things. And I understand the defense perspective of, if that's all he can testify to, it may do more harm than good, because it will leave the jury wondering, well, why didn't I hear about this? Why didn't I hear about that? And is it because the answers would not have been beneficial to Trump? And of course, they're instructed not to make that kind of supposition, but we all know that they do. And so that has to be part of any defense strategy about calling a witness when you have limitations about what you can question them on. Ultimately, the decision not to call that witness, is a very fraught defense strategic decision. And I'm not in a position where I can really Tuesday morning quarterback and say he should or shouldn't have, because I don't know exactly what that person would have said and whether or not the limitations would have rendered that a non-helpful witness, or whether subject to cross, there was other stuff that could have come out that would have been more damaging than what they would have got on direct. But I do think that it is, with regard to, the judge being the arbiter of the law. So this person is yes, talking about campaign finance law, but they become a fact witness in this particular case because the fact is that the law is a certain way when it comes to campaign finance violations. And the idea was that the jury should know, not that this is the law as the law, but this is the factual truth of what the law is. So when you are considering the facts in this case, one fact you should consider is that campaign finance law says X, Y, and Z. And therefore, when you're considering Trump's conduct, it does not violate X, Y, and Z. And that is a fact. So Mershon is the arbiter of law as it comes as it relates to the trial in New York. The actual criminal procedure law, the penal code that is being applied in this case, and the different evidentiary questions that come in, the rulings that he makes. But the fact of what is stated in campaign finance law and how it's applied is something that absolutely a witness under the right set of circumstances would be entitled to come in and testify to, and that does not encroach on the province of Judge Mershon in the case being the arbiter of law.
I've got two more questions in terms of whether or not the court is legitimate here. I've heard Trump express angst or umbrage that he was not allowed to comment on the trial. I believe he said that. Am I right in thinking that he absolutely could have gone up on the witness stand if he wanted to, but it would have been a horrible idea, and his attorneys probably talked him out of it?
Oh,
but
God.
That he had the opportunity to, if he wanted to, he could have gone and addressed the court?
Yes, he has an absolute... Yeah.
Well, of course, he's a criminal defendant. He has an absolute right to testify if he wants to, and it's his decision. His attorneys can't even make it for him. If he wanted to get up and testify, there is not a single person. The judge can't stop him.
Right.
His lawyers can't stop him. It is his constitutional right.
Yeah.
He could have done it. It is almost never a good idea for a criminal defendant to take the stand, and most defense attorneys will do their best to talk their clients out of it. But if the client decides he wants to testify, they cannot stop it. They have to permit it. I think what Trump is more talking about in this case is the fact that there was a gag order put in place on him that he violated probably 10 different times. So, you could say there was a gag order, but really he was outrageously, willfully ignoring it for the most part. And the judge was really very patient with him with regards to that. But gag orders happen a lot in criminal cases. Maybe not a lot. It's not a common thing, but it certainly does happen. And you would be hard-pressed to find a judge, actually, who is as patient and understanding as Mershon was with regards to his flagrant violations of the gag order. You could argue that a gag order was inappropriate, but it was in place, and it did not really stop him from saying what he wanted to say.
And the gag order in question was basically the judge said, you're not allowed to talk about the trial or something to that effect. Or
the witnesses, for example. And I think that's, one of the things I've heard people express frustration about is that, Stormy Daniels and Michael Cohen can run around and say anything they want about the trial and Trump and everything. And Trump wasn't allowed to respond or mention the witnesses. And I think that's why that's made him so fussy. Paul, what's your take?
No, I think he has semi-legitimate gripes about this because it's rare that witnesses in a trial want to go on the record and talk about it. But both Stormy Daniels and Michael Cohen have made a lot of money by being, the antithesis of Donald Trump. This is for both of them now their main source of income. So I understand why he feels aggrieved that he has been told specifically, just him, you are not allowed to talk about this, but other people can. At the same time, the way that he's going about doing it, the judge decided, you are potentially trying to influence the jury pool of prospective jurors, because this all happened, pre-trial and then carried through the trial. And the idea was that it's not a fair First Amendment issue here where they're allowed to talk and you're not allowed to talk. The issue is that both parties have a right to a fair trial of unbiased jurors, and you're out there trying to poison the jury pool by, going off and talking about how Alvin Bragg is corrupt, about how the judge is corrupt. This is a kangaroo court. This is a witch hunt. You're attempting to influence the potential jurors in the case to say that I'm not getting a fair shake, that I'm aggrieved here, that the prosecutions are corrupt in some way. And regardless of whether that's true, you can't say it.
Why did the judge not hold him in contempt of court? I would think that if
He
a judge issued a gag order, okay, so Trump has been held and convicted.
I think like 10 times or something, Paul, right? He was fined each time, and at some point, I do think that you're right, Paul, that they could have put him in jail for these violations, and they didn't. And there were like 10 of them.
So I agree. The judge clearly could have done more. I think this is just, this is my personal opinion. I don't have any basis for this other than what I think is likely to have happened. The judge was concerned. He knew that the eyes of the entire country were on him and his behavior here. He did not want to appear to be biased against Trump. So he actually did a decent job pre-trial of kind of bending over backwards to not be overly oppressive and aggressive towards him. He did try and maintain, decorum and maintain his own control over the case by issuing the gag order and by fining him. But he did not take the affirmative step of saying, I've given you try after try after try after try. Now you're going in, because he recognized how much that would fan the flames of every single person who was just saying, well, this is a witch hunt. This is a political prosecution. And had he put Trump in, that would have set people ablaze and saying, see, the judge is just jailing him now because he doesn't like him.
And it's his First Amendment, and how's he supposed to campaign? Right. And yeah.
Well, this was one of the other things that Trump brought up periodically was, I'm being required to come here to court instead of campaigning. And that was also not true. There were several times where he wasn't required to be there, that he went there, and then he would exit the courtroom and immediately give a campaign stump speech while having the bars behind him. So he was able to use this very theatrically as part of his campaign experience and has consistently been doing that. So this is one of the reasons that I find this so convoluted is I do think this is a weird law. I do think Alvin Bragg was a selective prosecutor. I would not have brought it to trial. I would probably throw it out in the appellate process. But Trump will go say things that are so hubristic, not hubristic, excuse me, hyperbolic. He will say things that are so hyperbolic, like the FBI was, told to use the option of lethal force when they came to Mar-a-Lago. This is for a different trial, mind you. But he'll say things like that, and when in reality, the prosecutor negotiated with the Trump team to go and find the stuff when the Trump family wasn't there. The policy was, you can only use lethal force if and under the circumstances that And so he's really, really going out of his way to make everything so beyond what's happening that he'll talk for a minute and I'll go, he says a good point. And then he'll just keep going and I'll go, oh, okay, this is just some weird framing or anchoring exercise he's doing, and he's lost me.
And it's so frustrating because he makes it and I guess that's what this election just feels so awful. And I have to admit that when the guilty verdict came down, I was devastated. And it's not because I don't want Trump to go to jail. I don't care what happens to Trump. But I do care what happens to the country. And all this did is escalate things. And, that's concerning to me. And, they've managed to do something that I didn't think was possible. They've managed to make me feel sorry for Donald Trump. I mean, at some point, it's very hard when you consider all of the trials, right? You've got, the $500 million disgorgement to the state of New York. You've got Letitia James, who also promised to campaigned on getting Trump for stuff. And, he does have the appearance of a man who's being hounded by the legal system all over the country. And so what the Democrats have done here effectively is lend credibility to his claims of a witch hunt, his claims that he's being persecuted, his claims that he's a victim of some kind. And, it's very sad. I see this trial. It alarms me. It makes me very uncomfortable with what the Democrats did here. And then Trump goes out and starts talking and you feel like, I don't want him to be president either, but this is bad. We're in a really tough situation, and I don't think that this trial helped. It's not going to settle anything. I think it's extremely unlikely that Trump will face any jail time for any of this, because it is, for somebody who is a career criminal, oddly enough, he's 78 years old, and this is his first offense. So I agree with you that Trump makes it very hard to he takes everything too far. He's his own worst enemy.
Yeah, or like another example where he will, like, literally during the conviction, as he's walking out of the courthouse following the conviction, he said, "This is the Biden administration coming after me." And anybody that has the slightest understanding of the mechanics of this would go, all right, a Democrat is coming after you, but this is a New York state court that is completely uncoordinated with the White House. You could allege that there was a conspiracy if you'd like, I suppose. But, I mean, in terms of the actual legal mechanics here, a Democrat came after you in a New York court, not the White House, not the Justice Department. And so, yes, I share your feelings on this, Anna. I think that somehow I have become sympathetic to Trump through all of this, and then he'll talk and I'll immediately lose any sympathy because I'll go, he's going back into circus performer mode. This is one of the other issues. With his defense, I'd love both of your input on this. I think he hobbled his own defense team on this. I think that this was actually a pretty easy case to win if he'd been willing to admit that he'd made any mistakes ever under any circumstance. And what I mean by that is he's saying, we are 100% innocent, nothing bad ever happened, this is a witch hunt from beginning to end, to the point that Trump has not permitted his legal team to admit he banged Stormy Daniels. That is something everyone else in America agrees he did. His legal team can't say that. He wouldn't allow them to say that. So if I had been his legal team, what I would have said is, look, Trump made mistakes in his personal life. A lot of people have done that. A lot of politicians have done that. It's not illegal to sign a non-disclosure agreement to make your mistress not try to affect the campaign. And by the way, a politician's job is to affect an election. That's not the illegal bit. The illegal bit was that it was misfiled as a legal fee rather than an NDA agreement. And that was a misdemeanor, and the statute of limitations is passed on that. That would have been my defense argument in a nutshell.
See, there's a couple different issues at play with what you're saying. First is trial strategy, and the strategy is the attorneys. The obvious, backlash to that is when you have a client like Donald Trump, who is such a public figure and such a powerful kind of controlling voice inside, the defense team itself. They want control. They want the ability to dictate strategy. They want you to do their bidding, even when you think potentially it might be not in their best interest to do the trial the way they want to do. I've had meetings with very high profile people who have said, this is going to be the defense strategy, where my colleagues and I have said, no, that's a losing strategy. If you do that, you will lose. And lo and behold, sometimes they go to trial with somebody else and they lose because that the person that they want, they just hired a yes man attorney and they took that strategy and they lose. But ultimately, it is the attorney who is supposed to be driving trial strategy. But in this particular case, when you have somebody like Trump who is so constitutionally incapable of admitting that he did anything wrong, this is the kind of thing that you have. And I've parsed through the defense summation. I think, largely you're right. You nuanced wise, you never really want to get up there and admit that your client did some of it, because that invites the jury to say, okay, they're already admitting he did some of it, so clearly he did all of it. But what you want to argue in this particular case is a very targeted, listen, for you to find that Trump is guilty of this, you have to find there's an underlying conspiracy with criminal intent to misframe this ledger entry as legal expenses for the purpose of concealing a crime. Ladies and gentlemen, that's just not what happened. And the evidence doesn't support that. Did Donald Trump have sex with Stormy Daniels in 2006? Sure he did. Absolutely. That's what happened. Was what happened in response illegal? No.
It's difficult as an attorney when you have a pushy client. And even in my work, there's always kind of a balance between, sometimes a client wants to present their case in a particular way, and I have to try to talk them out of it because I think they're unlikely to be successful. And I think that can be a difficult line to walk, and I can't imagine being Trump's attorney. I doubt he takes no for an answer. That said, though, while I agree that he hampered his defense, I'm not sure that was the deciding factor here. I don't think that the defense botched it. I do think that it would have been better to just admit that he had slept with Stormy. And honestly, from a legal perspective, whether or not he slept with Stormy should be totally irrelevant. If you pay somebody to be quiet about something, that's not illegal, whether it happened or not, until, the flip side, of course, would be, something like blackmail. But
I've filled out non-disclosure agreements.
Yeah, I have too.
When I got fired from a television network here a few years ago, part of the exit deal was, hey, we'll give you a severance package if you sign a non-disclosure agreement.
Yeah.
And it wasn't that they'd even done anything wrong. They just wanted to cover their bases and make sure I didn't try to make a career out of defaming them. And I didn't have sex with anybody that was higher up.
At least that you're willing to admit it.
Right. So I do think that there's something to that, Heaton. I do think that the defense could have taken a more surgical approach, is maybe the right way to say it, to really just hone in on exactly what the law says and explain and just keep explaining why under the law this doesn't quite work. This doesn't quite fit. They had a lot to work with. We're talking about crimes in 2017 that are alleged to have influenced the 2016 election. I don't think that was determinative here. Paul, you may disagree, but I just think that this was probably going to be a conviction no matter what. And I think that given that the law is written so broadly, that it gave the jury kind of a lot to work with if they felt inclined to find him guilty. And I don't think that a stronger defense necessarily would have changed anything.
Yeah, and look, it's very difficult, as a defense attorney, to sit and watch something like this that I'm not involved in. I'm not privy to the reams and reams of evidence that was gone. So I really try and shy away from Tuesday morning quarterbacking how a defense attorney did on a case when I am just not in a position to say, you should have done this, you should have done that, because there very easily could have been stuff that I'm not aware of that would have, shattered any defense strategy that I could have come up with. That being said, the strategy employed by Todd Blanche in his summation, which, because the transcripts of this case were all made public, I was able to get access to and read. The strategy employed by him was essentially just an all-out attack on Michael Cohen. I understand that. Michael Cohen is a very pivotal witness in this case for the prosecution. He is the one providing a lot of the testimonial evidence that puts Trump, in certain rooms, in certain conversations, that really kind of establishes the conspiracy. But I think what got a little bit lost for me, and obviously just reading it is different than hearing it delivered, and there's a lot of trial work that is presentation and pizzazz, and how do I move a jury, not just with what I'm saying, but the way that I am in the courtroom, my courtroom presence. But just reading through it, he doesn't really focus on why the prosecution hasn't really established the elements of the crime so much as go after Michael Cohen. And he does talk about the elements of the crime, but it's kind of in the middle. And that's, summation 101 is you lead strong, you build through the middle, and you end strong. If you put your biggest, most important stuff in the middle, especially when you're talking for hours, it loses its effect because the jury's not paying as much attention in the middle as they are in the beginning and the end. So you want to make sure that you're strategic about how you structure what you're going to say. And as I'm going through and as I'm reading it, I'm hearing a lot about Michael Cohen and this text message and this recording and this and that and this and that. And then in the middle, it's like, and here are the elements of the crime. They didn't do X, Y, and Z. But back to Michael Cohen, because he is the devil. He lies to everybody, and he's admitted to lying, and he's a liar, and he's a lying liar, and you should disregard him because he's a liar. It just felt like there were opportunities to say what needed to be said in a more concise way that were more persuasive. And I just didn't think that the raw focus on Michael Cohen, when there were other witnesses for the prosecution in this case that also provided evidence, I didn't think that was, it wasn't the strategy I would have taken. And again, I don't like to criticize other attorneys' strategies, but I felt like if I was a juror sitting and listening to that, it wasn't as targeted to what I needed to hear as perhaps it should have been.
And it's probably different in criminal law, but I mean, like in immigration, I do make an effort to always lead with my strongest argument, to keep it concise, because I just think as a consumer of information, I would like to present it in a way that I know it's easier to consume. And I think hours of circular arguments and lots of talking about Michael Cohen probably wasn't very impactful.
Right. Michael Cohen is a known commodity at this point. You can call him a liar 1,000 times. The jury knows from long before this trial started. Yeah. Michael Cohen is a convicted liar. You don't need to say it over and over again. You need to demonstrate why that's important. That's what so many people miss in summations. It's not about regurgitating the evidence. It's not about, remember when I asked Michael Cohen this and he admitted to that? It's explaining that question. The reason I asked that question and the reason that answer is so important is because it shows you this. Explain why it's important. Tie it together in a nice little bow and say every question that I asked on cross-examination was geared towards presenting this particular argument to you, and this argument is exactly why you cannot find the defendant guilty. Don't just malign a witness over and over and over again. The jury doesn't care.
I'm starting to think I know where Trump went wrong here. He should have hired you.
Yeah, good call.
I'm serious. That was a passionate defense. And I think that's, Again, I don't know that it was determinative. I think that the guilty verdict was likely no matter how strong the defense was. But I agree with Paul. I think that try to make it as...
Paul is a good defense attorney. I banged Stormy Daniels, and it didn't derail my career. I'm fine.
Right?
Yeah.
Right. You're doing fine, right?
Anna, you should go bang Stormy Daniels. That's right.
Oh, I've already... What?
So, final question for you both. You both have an advantage over me and a lot of the listeners, and you have a law degree. I don't have a law degree. I think I'm pretty good at discussing constitutional law, but I will admit I know nothing about criminal law. I know nothing about anything involving the actual prosecution and defense side of this beyond the regular person that watches Law and Order. So, as somebody that is a layman watching all of this unfold, the media portrayal is starkly different. It's like we're watching two different movies.
Oh, it totally is.
Movie one is about the rule of law and an Al Capone character who is delegitimizing the court, and the court and laws prevailing. Movie two is about a kangaroo court and a corrupt system that is ringing a guy through. For those of us that are laymen, how do we figure out how to navigate any of this? What advice do you have for us to where we don't just tune in and go, lawyer I agree with said X, but we have some amount of purchase in being able to understand what's happening rather than just defaulting on what we want to happen or being partisan?
I would say go to primary documents if you can. That's one thing I think. I also, sometimes I'll turn on the TV, and Paul and I talked about this earlier, I think. But, I put on CNN, and then for fun, I switched to Fox, and then I switched to MSNBC. And I'm telling you, it's like they're different trials. It's like they're covering different countries. So, if you want to know what the indictment actually said, it's available. If you want transcripts of testimony, that should be available to the public. I'm not sure what the timeline is for that, but I mean, it's technically a public trial. And I don't know, I just treat any bit of news with skepticism these days and double check it.
So you're right. Primary documents are really the best, but most people don't have, the time or the energy to get home from work and then, open their thing. So the Trump transcripts, because of the nature of this trial, were all daily rate published online. And so I was able to read transcripts, of the trial. And that really gave me an actual flavor of what the arguments were and what happened, because like you said, you can't rely on the media. I've had media coverage of my own trials that I have read, the following morning, and I'm like, was this person even in the courtroom? None of what they're reporting on actually happened. This is not what this person said. Nothing along these lines is remotely accurate. So I would caution people, only listen to those kind of partisan sites if you're only looking to just get confirmation of what you already think, because you're not going to get an honest accounting of what happened. The best thing that you can do if you don't have the time to really kind of sit and pour through these transcripts yourself, and for most trials you're not going to be able to get them. You have to order them, because this is how court reporters make money, is people ordering the transcripts. So like if you really wanted this and this was a normal trial, you would have to reach out to the court reporter and pony up hundreds of dollars and probably thousands of dollars for this trial because it was a long trial to get these transcripts. So there is a bar towards the average person getting primary documents on this. I would say, this is something I've written op-eds on in the past. I am a big proponent of cameras in the courtroom. And I had a shift on this probably 2 years ago where I was against it, but now I'm for it. I think this is the reason that cameras in the courtroom is such an important facet of our system. If we really want to have public trials, and we have the technology to make this extremely unintrusive, if you want to know how a witness testified, specifically what they said, how they came across, the best way to do it is to actually see clips of it. Put trials on YouTube. There are certain networks like the Law and Crime Network that publicize gavel to gavel certain trials, and you can sit and watch, and then you'll know exactly what happened, how this person testified, and what they said. And you don't have to rely on one news coverage saying this person was just made a fool of, by the cross-examination, and in the other networks saying, this person held up, like the most honest person that we've ever heard testify in trial, period. But I think that, that's something that hopefully we get to in the future. Right now, it's very difficult. I mean, there's no good answer.
I will add to this as a layman and as a pundit. I think if you were watching coverage where the people talking are mostly discussing personalities, they probably think you're stupid. If you're listening to a show where they're just talking about how great the judge is or how bad the judge is, or like I was hearing all this breathless commentary in preparation for this episode about how attentive the jury, just gushing about how attentive the jury was. At one point, I think Lawrence O'Donnell from MSNBC literally referred to Alan Bragg as the anointed one, referencing a document from Harvard that, it was all personality based. If people are just describing personalities, they think you're a moron and they're condescending to you. That's my hot take. Look for people that are going to explain law to you. There's still a certain amount of advocacy that might happen if you're getting partisan sources. And in those instances, I would look at it and think, are they operating at 100% or some amount? If it's all 100% sham or 100% rock solid, this is the best case that's ever happened, they're probably being something of a pundit there. But if they're explaining things and you feel like there's some amount of doubt, it's not either 0 or 100%, and they're explaining what's actually happening, that's what I'm looking for as a layman on my end, and why I contacted you both.
I was just going to say, I would like to commend to everybody Jacob Sullum's coverage of this trial for Reason. I think that and this is me because I'm third party, but I think, again, one other thing you could do is, look at who the person is commenting. Is this a journalist, or is this like a retired prosecutor who understands how trials work? And if you can find somebody who's willing to say something that maybe isn't good for their team, you're probably getting better information. But I think Jacob Sullum's coverage has been really good. I tend to gravitate towards pieces written by experienced attorneys rather than pundits. And I think that might be helpful too, although there's some amount of inside baseball. That makes
total sense to me. As somebody that is an armchair constitutional scholar who really enjoys reading Supreme Court decisions on constitutional law, the reporting from pundits on jurisprudence is awful. It is abysmal. It is a bunch of lazy people who do not want to take the time to actually read a decision that is their literal job to do, and so they just cast everything as red team versus blue team, and they portray everything as a bill passing through the Senate and what the Republicans and the Democrats are doing. It is lazy, and it is stupid, and it is condescending to listeners that do that. So I agree with you. I think finding people that are commenting on it that actually work in law or have worked in law is a very good maneuver to do. So dismiss me. but listen to Anna and Paul. Although I will say
Listen
on
to
my end,
Paul.
gang, my synopsis of this, having spoken to you over the course of this hour and a half, 2 hours, is I think that there was a zealous, potentially selective prosecutor operating with a very bad law on the books. But I'm not coming away from this conversation thinking that there was a misapplication of the law, that the judge was corrupt, that the courtroom was rigged, or that the jury was illegitimate. That's my takeaway: is bad law, court fine.
And I think that's important, Heaton. And I would say that, no matter how mad you might be or people might find this trial disconcerting, I want to stand up for the jury. Don't get mad at the jury. I think it's easy to blame them, and it's easy to assume they're just a bunch of Democrats who were, in the tank. But honestly, they can only work with the case that was presented to them. And I think the case presented to them was pretty tilted in favor of the prosecution, but it's not the jury's fault.
Mm-hmm. Yeah. So nobody be mean to the jury. If you see them over at Smokey Joe's and you're like, weren't you on the jury? Juror number 7, you piece of shit. Buy him a drink. Figure out, just ask him what he thought. Well, gang, I will go ahead and wrap it up there. Thank you so much for coming on. You're both very, very kind to take the time out of your day. I'll note that we're recording this on a weekend, which is abnormal, and so you all are taking time from your personal lives. Usually I do this during the workday and have it shoehorned in, but I wanted to get this out reasonably quick while it was still relevant. And on top of that, hopefully listeners will not pick up on this, but as I am in the woods and I only have limited ability to beam the Starlink up out of the trees, this has been cutting off pretty regularly every 15 minutes. And so we've had a real difficult time being able to hear each other. And so I really appreciate the patience you've both had. Folks at home, imagine a very glitchy technical call like on Zoom where it keeps crapping out. Now imagine you're discussing this topic with 3 people over an hour and a half. You two have been incredibly gracious and incredibly patient to put up with that. Thank you.
It's always a pleasure.
It's still better than the Ron DeSantis
that was
campaign
bad.
kickoff videos. So
Thank you.
You haven't hit rock bottom yet.
I'm shooting to hit rock bottom at 45. I'm only 40 now. I've got a little bit of time to go. All right. Before we wrap up, Anna, Paul, would you like to direct anybody's attention to anything? Paul, would you like to mention your podcast or point people to your defense firm in the event that they also bang Stormy Daniels?
Sure. If anybody out there is banging Stormy Daniels, feel free to give me a call. My firm is Robert T. Gottlieb and Associates. We do a lot of New York state and federal defense, but we travel all over. I've tried cases in Colorado, in Vermont, in Florida, in North Carolina, wherever the clients need us to be. We are a one-stop shop for your criminal defense needs. And I have a podcast of my own called In Summation, The Final Word, where I look at famous or infamous, as the case may be, cases, predominantly criminal, because that's what I know, but occasionally a civil case that has a constitutional bend to it. And I discuss a little bit of the background facts and what the arguments and maybe some of the pretrial rulings were to try and give you a real sense of how the case got to the resolution that it got to, so that you don't need to rely on media accounts of the case, which I constantly decry and explain why they are completely unreliable. So check me out, In Summation, The Final Word on Apple, Spotify,
okay,
wherever.
Anna, do you have anything you want to
podcasts.
push? You mentioned Jacob Solom earlier. Do you have anything else you'd like to throw out there?
Oh, I'm still just an immigration attorney, but if you find yourself in a non-immigrant status and bang Stormy Daniels and then get convicted for it and you need a waiver of inadmissibility, then you can reach me at kendallimmigration.com. I have a website now. It's very exciting. I don't have a podcast yet, but, I'm still here for immigration.
If you're an immigrant and you are currently paying hush money to Stormy Daniels, Anna Gorisch is who you want to go to. So everybody be careful about where we're going depending on what you're doing with Stormy Daniels and where you're located.
Well, and I can only help you with the immigration side of it. We don't want you deported.
Yeah, we can. We're a full-stop shop here. We can handle your criminal case and your immigration case.
I'll handle the porn.
Hopefully,
I'll handle the porn. That'll be me.
This is perfect.
So yeah, this is fine. Well, great. Thank you so much, gang.
Thanks.
Thank you.
All right, I hope that we have accomplished our goal today of being able to cogently discuss this trial. I can give you my tagline now on it, which is that a selective prosecutor used a bad law to felonize Donald Trump, and it should be thrown out on appeal. But the trial itself was not something that I would describe as a kangaroo court. It sounds like the judge and jury did their job and did their job adequately, and the allegations from Trump that it is corrupt and rigged are hyperbolic and damaging to the judiciary. But all the same, I would throw it out probably on Sixth Amendment grounds as just a dumb law to begin with, given that you don't have to clarify what the underlying crime was and so on and so forth. That's about where I'm at. Curious to where you're at. Patrons, feel free to put your thoughts in the comments. Now, I will also ask you to do something else this week. As I have had to produce this episode early, and I am in the process of driving back to Texas, I am not going to have time to do a standard bonus episode on the show like I normally do every single week of the year, save Christmas and New Year. There's always 50 episodes, I think, per year for patrons of the show. Since I won't have time to nail down a guest and nail down a topic, I will instead suggest that we do an Ask Me Anything. It could be about the Trump trial, but it could also be about literally anything that's been on the program in the last year. By definition, an Ask Me Anything entails asking me anything. So I will put up a separate post on Patreon from this that just says AMA Heaton, and any questions you'd like me to address in a bonus episode, please put them in there. We did this last year. It was a lot of fun, and got to a decent amount. I doubt I'll get to all of the questions. Please don't be insulted if I don't get to yours. It just kind of depends on how many there are. But we've got a very smart audience that asks very good questions and has very good thoughts. So that's what this bonus episode will be this week. On top of that, I will, when I get back to Texas, a few people have said, what is your scamp like? Scamp is not a euphemism here. It's the name of the camper that I camp in when I'm way the hell out in West Virginia or in today, Kentucky, and have dogs jumping into my car in a park and things like that. So I recorded a half-hour tour of my camper that I will put on an unlisted YouTube video so that you can see it if you'd like. So we will have those two things this week. We will have an Ask Me Anything and the Heaton Scamp Tour, so you can see my digs when I'm on the road or deep in the mountains or deep in the forest or just fleeing the law in general. And both of those things are a very big thank you to the patrons who make this program possible. You can join them by going to patreon.com/Andrew Heaton. That's patreon.com/Andrew Heaton. And if you would like to thank me for the work that's been going on, and you thought that today's episode was something that shone a little bit more light on the subject rather than heat, I would appreciate it if you thanked me by going to patreon.com/Andrew Heaton. Okay, thanks. That's the show. Thanks for listening. Thank you, Paul Townsend and Anna Gorisch, for coming on. Thank you, patrons, for making it possible. Thank you, United States Forest Service, for the fine work you do. I tend to decry the government a lot, but I have a real soft spot for the Forest Service. I think they do fine work. If they sell a hat, I would wear it. That's how much I like the USFS. Until next time, I've been Andrew Heaton, and you've been indicted.